Hi, it's Jason here at Fraser Valley Rose Farm, and I'm making what is an emotional and complicated video today about the question of ownership. My right to own my own property, the results of my labor, this land here, and how solid is the foundation on which that stands. This all stems from a ruling that happened about some land in Richmond, on an island quite like this, but just further down the river, where the Cowichan band has received title to certain properties. I want to talk about that and what it means for land ownership in Canada. I'm going to throw some headlines up on the screen here as we talk about this, and what you will quickly see is that the headlines are all over the place. This is a hotly contested issue. Sadly, polarizing issues like this draw politicians, the Conservatives here in BC saying the Liberals are at fault and this is a disaster, other people coming out and saying it's no big deal, don't worry about it, this has no impact on your property rights. The legal experts, on the other hand, are somewhere in the middle, saying this is actually a very serious and consequential decision and could have large impacts into the future, set precedents for land ownership in Canada. But just to put the emotional point on this, the most wrenching scenes come from town hall meetings in the city of Richmond involving the 150 landowners, mixed-use land properties. These are some industrial, some farms, some residential properties, who had their fee simple titles encumbered at this point, changing their rights to their own property. When I say changing, making it subordinate to the Cowichan claim on their land. So the result being that they can no longer sell their land. It may also impact, is what I'm hearing, their ability to receive financing on that land. So basically it's like almost having a lien on your property, except in this case the superior right to the property goes to the Cowichan band rather than the initial landowners. So we have kind of a situation here where these people woke up one morning, got a letter in the mail from the mayor of Richmond saying this is what's happened, and they had no idea before that time, or if they'd heard about it, it was just from their own research. Importantly, and maybe even alarmingly, the justice in this case, Justice Young, made decisions early on that excluded these, what she called the third-party landowners, out of the case, saying they didn't really need notice, they didn't need representation of their interests, that they were just left out and then informed afterwards what happened, even though their rights were dramatically impacted by this. And this is where she obviously did this for legal and practical reasons, but from a farmer's point of view, me looking at from the outside, the question of fundamental justice comes up. How does a person whose interests are dramatically affected by the ruling not have the right to due process or fairness under the law? Don't know how that happens. This is obviously where empathy comes in, and maybe a little bit of fear, in that you don't want to see individuals, just regular people, being dragged through a court process that they didn't even know was happening and having their rights changed to their detriment without any due process. That makes it concerning, but I will throw a silver lining on this straight away, or sort of some damage control, is that the person who's going to make this right probably is the province of BC. They were a party to the case, and the judge went away encouraging them to get right in there and start negotiating a settlement and put a delay on the implementation of the ruling so that that could start to happen. Sounds to me like the Cowichan tribe themselves are very receptive to that process and very supportive of the fee simple title holders. So in the end, this might be a happy ending for all involved after some uncertainty. Now, for other people in the Fraser Valley here, or for across Canada, the question then becomes, well, what happens to my fee simple title? Could this just come out of nowhere and affect me? And on the face of it, before we go into the specifics of the case, you might think, well, maybe yes. I mean, as it comes to BC here, we are constantly told how much of British Columbia is unceded territory. Some estimates might be up to around 95% of British Columbia here is considered unceded. So you think the analogy, well, if that island over there had some unceded territory and then this ruling came out sort of blindsiding the fee simple title holders, then why couldn't that happen to me? And for that analysis, you have to look specifically at the case. So I will link below the video the actual ruling, which is extremely dense. And what the Cowichan representatives have brought up, their lawyers have mentioned, that this did not come out of nowhere. The specifics of this case are very particular, and historically, this is a very limited set of circumstances. What we're talking about here was that the village on Lulu Island was a very well-defined area pre-colonialism, and that something happened during those granting of lands where they were promised this specific land, that this was actually set aside for them, but then that was reneged upon, and reneged upon improperly by what we'll call malfeasance on the part of the people who were granting it. So we have a very specific set of facts here that are not easily replicated elsewhere across the province or across Canada. It should be said right at this point that most of the dealings with Indigenous claims, First Nations claims, are dealt with through treaty negotiations. In this case, because Richmond is such an urban area and there were so many governments involved and they were dragging their feet for a long time, it almost seems like the Cowichan were kind of forced to press the lawsuit to bring this thing to a conclusion, ending up where the judge in this case kind of forced their hand, saying, look, this was going to end up on the negotiating table at some point or another. Let me make the ruling that forces you to the negotiating table. So we have every reason to believe that most First Nations will continue with the treaty process, and a lot of the local First Nations groups are actually deep into that treaty process. I think the local Stalo is somewhere in the range of stage 4 or stage 5 in a 6-part process. Don't quote me on that, but they're deep into negotiations already, and it seems overwhelmingly likely that what they will do is they will get a grant of Crown land, that they will get some financial compensation, but that fee simple titles will be excluded or protected under those treaty negotiations. So the last lingering question I had on this when I looked at all of the research on it was, how was it that these fee simple landowners ended up in the middle of this, kind of not able to get representation in this court hearing, kind of blindsided by the whole process? How is that fair? How is that just? How does that respect their equal rights under the law? And the answer to that is a little bit troubling for Canadians, although, again, it isn't going to come up that often, and that comes down to this: that property rights are not a constitutional right in Canada. They're dealt with under common law or other laws within Canada, but they're not a constitutional right. And this suit, even though it sounds like it's a property suit, was constitutional in nature, I believe, because of the First Nations claims. So that's why I think the judge had to segregate this issue and make the kind of constitutional ruling separately, and then leave the province on the hook to sort it out civilly after the trial. I want to make a bad analogy here, but it's like if you called the police to a store and said they won't give me a refund, the police would probably say to you, well, that's a civil matter, because there's two different kinds of law happening there. There's criminal law and civil law. Bad analogy, I know, but it's the point of saying the judge kind of set them outside of this process because that's a different kind of law that has to happen. They may have a suit, a civil suit, against the province, or a right to compensation from the province, but in this case, they didn't have standing. She ruled in this constitutional case. All right, thanks so much for watching. I know, very different topic from me, and this goes without saying, you shouldn't take your legal advice from YouTubers. You certainly shouldn't take your legal advice from farming YouTubers, but that's my interpretation. I couldn't ignore it because it is something that is quite relevant to me, but there you have it. I hope you found that useful, and go ahead and leave comments down below.